What if I told you that being an American citizen might not be as permanent as you think? Your blue passport, your oath of allegiance, even decades of living as an American, all of it could be taken away. And if you're one of the 26 million naturalized citizens in the United States, especially if you're Indian American, you need to hear this right now. Stay with me, because what's happening could affect millions of families, and the clock is already ticking. Hey everyone, welcome back to US Visa Updates, your trusted source for everything related to American immigration, visas, and citizenship. I'm your host, and today we're diving into something that's sending shockwaves through immigrant communities across America. We're talking about denaturalization, the process of stripping naturalized Americans of their citizenship. And under the current administration, this isn't just a rare legal tool anymore. It's becoming a systematic enforcement mechanism with numerical targets that could potentially affect hundreds of thousands of people. If you or someone you know is a naturalized citizen, you absolutely cannot afford to miss this video. So hit that subscribe button, turn on notifications, and let's get into what's really happening with American citizenship in 2026. Let me start by painting the full picture of what's unfolding right now in the United States. The Trump administration has made immigration enforcement a cornerstone of its policy agenda, but what we're seeing now goes far beyond border control. This isn't about who gets into America anymore. This is about who gets to remain American. And that distinction is absolutely critical. According to internal guidance that has been circulated within the United States Citizenship and Immigration Services, commonly known as USCIS, there's been a directive issued that fundamentally changes how denaturalization will be approached in the fiscal year 2026. The document explicitly instructs immigration field offices across the country to identify between 100 and 200 cases every single month that would potentially qualify for denaturalization proceedings. These cases would then be referred to the Department of Justice for prosecution. Now, let me put this into perspective for you because the numbers are truly staggering. Since 2017, which gives us roughly an 8-year window, only about 120 denaturalization cases were filed in total across the entire United States. That's approximately 15 cases per year on average. But under this new guidance, we're looking at a minimum of 200 cases per year. That's 100 times increase. And if offices hit the upper target of 200 cases per month, we're talking about 2,400 cases annually. This represents an exponential escalation of a process that was designed by federal law to be extraordinarily rare. Let's talk about what denaturalization actually means under United States federal law. The legal framework is quite specific. American citizenship, once granted, is supposed to be virtually irrevocable, except under very narrow circumstances. According to current federal statutes, citizenship can only be stripped away if a person committed fraud during the naturalization process, or if they fall into a few other narrowly defined legal categories. These might include concealing material facts during the application process, willfully misrepresenting information, or obtaining citizenship through illegal means. The key word here is fraud. There has to be intentional deception, not just honest mistakes or administrative errors. But here's where things get concerning, and this is what has immigration attorneys, civil rights organizations, and former immigration officials sounding the alarm. When you impose numerical targets on a process that's supposed to be rare and reserved for egregious cases of fraud, you fundamentally change the incentive structure. Immigration field offices now have quotas to meet. They need to find 100 to 200 cases every month. And when you're working under that kind of pressure, there's a very real risk that the bar for what constitutes fraud gets lowered, that minor discrepancies get elevated to major offenses, and that honest mistakes made decades ago suddenly become grounds for citizenship revocation. Former U.S. immigration officials who have spoken to media outlets have expressed deep concern about this shift. They point out that many naturalization applications were filed 10, 15, 20, or even 30 years ago. The people who filled out those applications were often doing so in their second or third language. They were navigating complex bureaucratic systems, often without legal representation. They might have made mistakes about dates, about previous addresses, about past employment, about trips taken years earlier. These errors, which at the time might have been overlooked or corrected through routine administrative procedures, could now be recharacterized as fraud. Imagine this scenario. You're an immigrant from India who came to America in the year 2000. You went through the entire legal process. You obtained a work visa. You got your green card. You waited the required 5 years. You studied for the citizenship test. You learned about American history and government. You took the oath of allegiance, and in 2008, you became an American citizen. You've been living as an American for 17 years now. You've paid your taxes. You've raised your children here. You've built a career. You've bought a home. You've voted in elections. You've served your community. And then one day, an immigration officer reviewing old files notices that on your original naturalization application, you listed 3 trips outside the United States when there were actually 4. Maybe you forgot a short business trip to Canada. Maybe you miscounted. Maybe the dates overlapped in a confusing way. Under the old system, this would likely never even be noticed. But under a quota system where officers need to identify hundreds of potential denaturalization cases every month, suddenly this becomes a material misrepresentation that could form the basis for stripping your citizenship. The Trump administration, to be clear, is completely unapologetic about this approach. Official statements from USCIS emphasized that the agency will prioritize denaturalization efforts targeting individuals who they claim unlawfully obtained U.S. citizenship. Government officials argue that this initiative is fundamentally about restoring integrity to the immigration system. They say it's about rooting out fraud, about identifying people with gang affiliations, about finding individuals involved in financial crimes, about exposing cartel connections, and about removing violent offenders who should never have been granted citizenship in the first place. The Department of Justice has reinforced this messaging with its own directives. Prosecutors across the country have been instructed to maximally pursue denaturalization proceedings wherever the law potentially allows. This language, maximally pursue, is significant. It suggests an aggressive, proactive approach rather than a reactive case-by-case evaluation. It implies that prosecutors should be looking for opportunities to denaturalize, not just responding to clear-cut cases of egregious fraud. Now, it's important to understand that this denaturalization push doesn't exist in a vacuum. It's part of a much broader, comprehensive immigration enforcement strategy that has been unfolding since the beginning of Trump's second term. We've seen dramatic tightening of asylum rules at the southern border. We've witnessed a pause on asylum applications being processed inside the country. There have been sweeping restrictions on entry for people from predominantly African and West Asian nations. The administration has announced what they call a permanent pause on what they term third world migration, specifically naming countries like Afghanistan, Haiti, and Somalia. But here's the crucial shift that everyone needs to understand. All of those previous measures were about people trying to enter the United States. They were about border control, about visa restrictions, about who gets to come to America. This denaturalization campaign is fundamentally different. This isn't about people at the border. This isn't about asylum seekers. This isn't about undocumented immigrants. This is about naturalized American citizens, people who have already gone through the entire legal process, people who have already sworn allegiance to the United States, people who have already received their citizenship certificates and their American passports. The target has shifted from those seeking to become American to those who already are American. Let's look at some numbers that really drive home the scope of who could potentially be affected. There are currently 26 million naturalized Americans living in the United States today. That's 26 million people who were born in other countries but went through the legal immigration process and became U.S. citizens. And the pace of naturalization has been accelerating. Last year alone, more than 800,000 new citizens were sworn in across the country. That's nearly 1 million people who took the oath of allegiance, who received their naturalization certificates, who believed they had achieved the American dream. And here's where this becomes particularly relevant for our audience here at US Visa Updates. After Mexico, which is the largest source country for naturalized American citizens, India ranks as the second largest. In 2024, nearly 50,000 Indian born immigrants became American citizens. That represents more than 6% of all naturalizations in the United States. The Indian American community, which has grown to become one of the most successful and well-integrated immigrant communities in America, is now among those most statistically exposed to this policy shift. Think about what this means for Indian American families. There are millions of people from India who came to America on H-1B visas who worked in technology, medicine, engineering, business, and academia. They followed every rule. They paid every fee. They waited through every delay. Many waited 10 or 15 years for green cards due to country-specific backlogs. They raised children who were born as American citizens. They bought homes, started businesses, contributed to their communities. And after finally obtaining citizenship, often after 20 years or more in America, they believed their status was secure. They believed citizenship meant permanence. But now, with these denaturalization quotas in place, there's a new layer of uncertainty. Immigration attorneys are already reporting increased anxiety in immigrant communities. People are asking questions they never thought they'd need to ask. What if there was a mistake on my naturalization application? What if I forgot to mention something? What if there's a discrepancy between what I wrote on my green card application and what I wrote on my citizenship application? What if my name was spelled differently on different documents? What if I listed my employment history slightly differently on different forms over the years? These are the kinds of questions that keep naturalized citizens up at night. Now. And the concerns are particularly acute for people whose naturalization occurred many years ago because memories fade, old documents get lost, and reconstructing exactly what you wrote on a form 15 years ago becomes nearly impossible. Yet that old paperwork could now become the basis for losing everything. Your citizenship, your right to live in America, your ability to stay with your family, your career, your entire life. Legal experts are warning that the combination of numerical targets and aggressive prosecution creates what they call a chilling effect on immigrant communities. People become afraid to travel internationally because re-entry could trigger additional scrutiny. People become hesitant to apply for government benefits they're legally entitled to because any interaction with government agencies feels risky. People avoid updating their addresses or reporting changes in circumstances because every piece of paperwork feels like a potential trap. This fear, experts say, is corrosive to both individual well-being and to the broader fabric of American society. There's also a question of fairness and equal protection under the law. If immigration field offices have quotas to meet, will certain communities be targeted more than others? Will people from specific countries face disproportionate scrutiny? Will individuals with certain names or certain backgrounds be more likely to have their old applications reviewed? These are questions without clear answers right now, but they're questions that deserve serious attention and oversight. The implications extend beyond individual cases. This policy sends a message to the entire world about what American citizenship means. For generations, American citizenship has been seen as the gold standard. Once you became American, you were American. Period. Your allegiance was accepted. Your status was secure. Your rights were protected. But if citizenship can be routinely questioned, reviewed, and revoked based on old paperwork, then what does American citizenship really mean? Is it a conditional status that can be taken away at any time? Is it something that naturalized citizens hold differently than natural-born citizens? Does it create a two-tiered system of citizenship where some Americans are more vulnerable than others? These aren't just philosophical questions. They have real practical implications for millions of families. Parents worry about what happens to their American-born children if their own citizenship is revoked. Professionals worry about losing careers they've built over decades. Homeowners worry about losing property and investments. elderly immigrants worry about being deported to countries they left 30 or 40 years ago, countries where they may no longer have any connections or support systems. So, what's the bottom line here? For the 26 million naturalized Americans living in the United States, particularly for the millions from India and other countries who followed every rule and believed their citizenship was secure, the landscape has fundamentally changed. Your American passport may still be blue, but in 2026, your citizenship is no longer as bulletproof as it once was. And for many people, that changes everything. This is a developing story, and here at US Visa Updates, we'll be following it closely. We'll bring you updates on legal challenges, on individual cases, on policy changes, and on what you can do to protect yourself and your family. If you're a naturalized citizen, now is the time to review your old immigration paperwork, to consult with an immigration attorney if you have any concerns, and to make sure all your documentation is in order. If you found this video informative, please give it a thumbs up. Share it with anyone you know who might be affected. Your friends, your family, your colleagues. The more people who understand what's happening, the better prepared our community can be. Subscribe to US Visa Updates if you haven't already, and hit that notification bell so you never miss an update on immigration news that matters to you. Drop a comment below and let me know what you think about these denaturalization policies. Have they affected you or anyone you know? What concerns do you have? Thank you so much for watching, and remember, stay informed, stay prepared, and stay connected. I'll see you in the next video. Until then, take care and God bless America.